Ladies and gentlemen, welcome to this BUL International Law Group event on outer space and international law. Today, we have brought a panel of speakers in order to discuss space law in essence, a field of law that is not usually tackled upon in international discourse. And along these lines, we have brought speakers from all over the world, literally, Australia, Canada, and together with us also, we have the BUL School of Law staff that we're going to discuss in the next hour or so all the implications of the event. The event is going to be chaired by Dr. Lisa Mardikian, senior lecturer here in the BUL School of Law. And with no further delays, I pass the microphone to Dr. Mardikian in order to introduce to you the speakers and proceed with the event. For my part, just to note that the event is going to be recorded. It's going to appear afterwards on the Brunel Law School YouTube channel. And Dr. Mardikian, the microphone or podium is yours.
Thank you, Solon. A warm welcome also from me to our panelists and to the audience. Our first speaker is Professor Dale Stephens. He is captain in the Royal Australian Navy Reserve, and he spent over 20 years as a permanent officer in the Royal Australian Navy before taking up his appointment at Adelaide Law School. He has occupied numerous staff officer positions throughout his career in the Australian Defence Force, where he was involved providing legal advice regarding numerous operational, disciplinary and administrative law issues, including fisheries, UN peace operations and the implementation of international treaties such as the ICC Convention. Professor Stephens has been deployed twice to East Timor and twice to Iraq in senior legal officer positions. At Adelaide University, Professor Stephens is director of the Adelaide Military Law Program and chair of the Woomera Project Governance Board, and he has also taught at the Australian National University College of Law. So, Professor Stephens, the floor is yours.
Thank you very much, Professor Matakan. I'm very grateful to be here and thank you for inviting me. It is currently 11:35 p.m. at night as I speak, so bear with me if I look a bit sleepy. I'm going to be speaking in the next 10 or so minutes about space law, but with a particular focus on military issues and where we are right now in that regard. It is my view that we're at a critical moment when it comes to military issues in space that does require the attention of a lot of international lawyers to try and deal with what might be on the horizon. It is a fact that states are including in their military law manuals references to space. Not a lot of reference yet, but it's increasing. We've also seen NATO declare space as an operational area, and a number of states themselves have declared space as a military operational area. And certainly the US, China and Russia have all developed space military doctrine, and that is governing a lot of their actions. And indeed, we see, unfortunately, weapons testing in space, or at least anti-satellite weapons testing in space. The sorts of weapons that might be utilised in space are anti-satellite missiles, and Russia, China, the US and India have all tested their capabilities or demonstrated their abilities, directed energy weapons, cyber weapons, jamming, etc. Is this a law-free zone? The answer is no. Of course it's not a law-free zone, and the Outer Space Treaty makes it plain under Article 3 that all international law applies to space, including the UN Charter. So whatever states might want to do in space, they are governed by international law, and particularly the UN Charter. But let's be clear about what is and isn't included specifically in space law. Space law doesn't spend a lot of time on military issues. It talks about weapons of mass destruction not being in full orbit around the Earth or being on the moon or being situated in space. It talks about specific prohibitions on military forts and fortifications and weapons testing on the moon. But outside of those specific restrictions, there's a lot of latitude. And this is where I think international law must apply. What sorts of issues are on the horizon when it comes to the jus ad bellum type concepts? ASATs, I fire a missile into space and shoot down one of your satellites. Am I violating Article 2.4? Do I have a right of self-defense under Article 51? I think the answer is pretty clearly yes. But then we step down from that. If I start using lasers or I start blinding your satellites, but no damage, am I violating Article 2.4? Do I have a right of self-defense? If I have temporary impairment of a satellite, does that give me a right of self-defense, or at least of a countermeasure? If I jam satellites, if I jam your satellite, is that a violation of Article 2.4? And of course, cyber, if I use cyber means against your satellite, what does that mean in the spectrum of use of force? And of course, we've got quite a vocal and animated discussion on cyber operations, the Tallinn Manual, of course, being a key reference for that in that regard. So there's a lot of action going on in space, a lot of questions that are being asked, and it becomes a critical moment for us and for states in particular to come to conclusions about where on the spectrum all of these actions and reactions lie under international law as we know it. Then let's move on to something that we don't want to talk about, but we've got to acknowledge might happen in space, and that is armed conflict in space. God forbid should that occur. And that raises another set of questions about how does international humanitarian law apply to space, and in what way does it apply? Is there anything in IHL that applies to space? Well, there's no treaty anywhere that says specifically that these provisions apply in IHL, at least, except for one provision of the Environmental Modification Treaty that does make reference to space. So we're left with a lot of uncertainty. But states and international organisations such as the ICRC are tentatively trying to fill those gaps, are trying to find how and articulate how the law of armed conflict would apply to ameliorate violence and to protect civilians and protect neutrals, if such a thing is possible in space. Questions that emerge, astronauts have a specific status under the Outer Space Treaty, envoys of mankind would say humanity now. What if you're a military astronaut? Do you have particular protection or not, given Article 5? Probably not. The law of armed conflict probably is the lex specialis, but it raises questions about how that law would apply. Questions of distinction, a satellite, a military satellite or a civilian satellite engaging in military use. Or transponders, particular transponders on a satellite that are engaged in military use and others that are not. How does the law regarding distinction apply to attacking such a satellite? Medical satellites, we're not there yet, but the use of the use of telesurgery is something that seems to be on the horizon, and perhaps you'll have special protection for military satellites that are engaged in such telesurgery on the battlefield, and they will have a protected status. The question of proportionality looms large. I spoke earlier about ASATs, kinetic means of attacking satellites. Well, if you do that, you can with some confidence predict how debris would then disperse and how it might then hit other satellites. And you might find that the law of proportionality precludes you from using ASATs in order to attack an enemy satellite. I want to come back to that very briefly in a minute with the war in Ukraine. And then precautions in attack under Additional Protocol 1 and customary international law. If I'm going to attack a satellite and we've got the potential for debris, am I bound as a matter of law to not use kinetic means, but to use lasers or to use cyber? As a matter of law, if feasible, the answer is yes. But when is it feasible and in what circumstances would it apply? And then the final question that I want to just raise that many states and academics are grappling with is direct participation in hostilities. One of the great features of space is that you've got many talented people in many areas involved in space operations. The law of armed conflict, of course, allows you to target civilians taking a direct or active part in hostilities. When in the range of activities dealing with space is a civilian taking a direct or active part in hostilities such that they may be targeted? And that's a key question that does need resolution. In the few minutes I've got left, let me just talk a little bit about the war in Ukraine and how this provides a real case study on how the law might be developing in the context of the law of armed conflict. Ukraine had no dedicated military satellites. It called on other states, it called on commercial providers to provide it with intelligence, to provide it with information from their satellites. General J. Raymond said that this Ukraine war is the first war where commercial space capabilities have really played a significant role. States are companies are providing information to Ukraine in respect of that armed conflict. What does that mean? Does that make those satellites targets? Well, the answer is yes. Under the law of armed conflict, if you're being used to ensure a military advantage for a belligerent, then yes, under the law of targeting, they may be targeted. Does that mean that Russia does have a right to engage those satellites? Well, the Russian government has said yes, and I don't think that they're wrong. If your enemy is getting supplied with commercial information that has military value, then yes, you lose your protection. But here's the thing. What we're finding is Elon Musk, who's launched 2,900 satellites and is providing free satellite services to the Ukraine, including supplying military information, that provides a lot of targets. That provides too many targets in some respects in order to deal with that. So we don't see kinetic means of engaging those satellites. What we see is Russia using a lot of jamming and choosing to rely upon jamming those particular satellites. And that is interesting because it's a grey area in the jus ad bellum context of whether or not you cross a line of Article 2.4 or not. So my point being that what we're seeing in the war in Ukraine in space is action and reaction, but a level of restraint in terms of dealing with satellites in armed conflict. And I think that we will all draw some conclusions, the states will draw some conclusions from that. I might have painted a pretty, I'm going to finish off now. I hope I haven't painted a pessimistic picture. What I want to say is that the law of armed conflict operates to ameliorate violence and protect civilians and civilian objects. And I think the challenge for academics and the challenge for states is to determine with a level of specificity, which we haven't quite seen yet from states, just how that is done. But it must be done. With that, let me end and open up for questions or whatever happens next.
Thank you very much, Professor Stevens, for this very thought-provoking presentation. We have a bit of leeway, 5 minutes or so, if anyone from the panel wants to ask any questions or make any comments.
Maybe Dr. Mardikian, if Professor Jakhu wants to say something. Professor Jakhu, do you want to comment on something on this?
I will say I ditto everything what Professor Stevens said. He did a brilliant job. I must say I really admire how brilliantly he described the the Ukraine situation, particularly with respect to the participation by private companies. This is what I was wondering, that if you can answer that question early, as he did it. Fantastic. Well done there, Professor Stevens.
Oh, thank you, Professor Jakhu.
And maybe one of our colleagues here wants to ask a question. Till we are thinking about this, I have a question that is tormenting my mind all this time, and Professor Conway wants afterwards to follow. But maybe once I'm speaking now to answer the question. The question, Professor Stevens, is about jus ad bellum. You said that the temporary maybe jamming of the satellite will not constitute an attack under 2.4. What about, though, the fact that on jus ad bellum on the ground, on conventional warfare, according to Deinstein at least, even an isolated incident, if it is of gravity, it can give rise to the right of self-defense, meaning Article 51 of the UN Charter. Why don't we apply mutatis mutandis, the same idea, also on space? This is my question. And maybe Dr. Mardikian, we want to hear also the question from Dr. Conway, and then to proceed, it's up to you.
Yes, we can collect. Yes, and just to let you know, we have also one question in the Q&A chat box, but we are collecting all of the questions at the end. And
exactly, now it's this discussion for the audience, for you to get inspired by us as we speak orally. In the end, we're going to address also your question as the audience.
Please, Gerard.
Yeah, thank you for the presentation. If you don't know much about, I guess you either know something about outer space law, or you don't know very much. And I have to say I don't know very much about it, but it was very clear the way you explained things and identified the issues. I want to ask you about the you mentioned the International Committee of the Red Cross was doing work to develop standards and principles in the area. What's the approach of, I suppose that the states most interested are the states who have space programs and who are active in space. What is their approach to the issue? Do they tend to sort of have their own sort of foreign policy approach to it, or is there any kind of coordination between these states? Are they working together to develop standards, or what's the current state of play amongst major powers?
Thank you very much. Perhaps Professor Mardikian, if I could answer those two questions, are you okay with me doing that?
Of course. Yes.
So firstly, the first question, Salon, is that I'm not saying, the point I'm making is that absolutely Article 2.4 applies into space, and Article 51 and all of the normal law. In fact, the Article 3 of the OSC says exactly that. But what I do want to point to is state practice. And what you have seen, one of the things we're doing, and Lisa made mention of the Woomera Manual, one of the things we've been doing is tracking state practice over the last 50 years. And what you're finding is that states, when it comes to satellites, have been engaging in quite elaborate jamming activity, jamming and spoofing activity. And when that has occurred, the reaction of states is to protest. And we have multiple examples of states protesting. The US State Department, NATO nations protesting. But we have not found any instance ever of any state that has said that jamming of their satellites, and I'm putting, let me be clear, I'm putting to one side early warning satellites, early nuclear early warning satellites. They're in a category of their own, but normal satellites, normal surveillance, reconnaissance, communication satellites, we have yet to find any instance of any state ever saying that you have now crossed an Article 2.4 line. I can see why you could, I can make an academic argument for why that could occur, but there's been a total reluctance so far for states to make that claim. So guided by that, I have a level of confidence by saying that jamming is in that grey zone, and it's why I think Russia is doing that rather than destroying satellites, because it is in that grey zone, was my view. As to Gerard's question, yes, there's been, as I said at the beginning, the United States has in their Law of War manual, they have got some commentary about the application of the law of armed conflict to space, but they're probably at the vanguard of states saying anything about this, at least in their established manuals. And so it raises the question, what elements of the law of armed conflict do apply into space? Because surely it must. Surely it's not a Wild West. If the worst case happens and there's armed conflict, surely the law of armed conflict applies. And you can point to judgments, the Nuclear Weapons Advisory Opinion. You can look at the actual wording of the Geneva Conventions. But the problem with a lot of conventions is they're bound to land or sea, or in some instances, an additional protocol 1 to air. And so what you've got to do is distill down key universal principles, distinction, proportionality, precautions that apply as a matter of customary international law everywhere, and then make an assessment on how they would apply. And the ICRC is on record with a statement that they made a couple of years ago about how they would apply in order to restrain states, restrict states. And it's a starting point. It's a starting point for discussion. As Lisa said, we've been involved in the Woomera manual, and I know that Ram will no doubt talk about the McGill manual, but in the context of the Woomera manual, we have been engaging with states, and we have asked them their views, and they have volunteered them. They have volunteered with a level of caution because thankfully, there's been no armed conflict in space, and hopefully it will remain that way forever. But in the event that it does happen, we want to make sure that there's law available to restrain activity. And so that discussion, I would say, has just started. And I think we will see in the next decade or so more specificity from states in regards to this issue. And of course, there is the open-ended working group, that UN open-ended working group that is looking at that. And there's a difference of opinion about whether this should always even be discussed. I know some states choose to not discuss it, where others say, no, it is time that we discuss this. And so we're in that moment, I think, of time.
Dr. Mardikian, out of curiosity now, because Professor Stevens mentioned the last sentence of his, some states are ready to discuss, some are not ready. To assume that developed states are not ready, developing states are ready. Well, how does it work, like in other fields of international law?
I can't find it, in my view, and I'll get Ram's or Professor Jakhu's comments on this, but I've not seen a split like that. I've not seen developing. I've just seen different states with different views, from Asia, from Europe. You know, it's from Africa even. It seems to be states that are just willing to, for whatever reason, make a statement. So far, I've not seen any clear division yet between who's talking and who's not.
Can I just ask you? You mentioned Article 3. What instrument was that? I didn't catch the.
Oh, sorry, that was of the 1967 Outer Space Treaty.
Okay, thank you.
And that's one of the, just on this point, that's thankfully in this area, you find that in the area of military activities, you'll find many states, or some key states, are not party to Additional Protocol 1 or Additional Protocol 2. But you'll find with the Outer Space Treaty, Russia, China, the United States, India are all parties to the OST, which makes it very for a lawyer, it's a very thankful thing that you've got this treaty that all the major parties have ratified. So it's a good thing.
Okay, thank you very much. If there are any other comments, we can move on to Professor Jakhu's presentation. Professor Jakhu has over 40 years of experience in space law and policy, and currently he is a tenured full professor at the Institute of Air and Space Law at McGill University. He is the project director and co-editor of the McGill Manual on International Law Applicable to Military Uses of Outer Space, project director and editor-in-chief of the McGill Encyclopedia of International Space Law, and research director on projects on space laws and policies in South Asia. He has held a number of other positions, including that of a member of the Canadian Human Rights Tribunal and a member of the Global Agenda Council on Space of the World Economic Forum. Among others, Professor Jakhu has received the Leonardo da Vinci Lifelong Achievement Award from the International Association for the Advancement of Space Safety in 2016, and in 2007, the Distinguished Service Award from the International Institute of Space Law for the significant contribution that it has to the development of space law. Professor Jakhu, the floor is yours.
Thank you very much. First of all, I want to thank the organizers to invite me. And I'm particularly pleased with Professor Stephen's presentation. I'm actually privileged to be on the panel with him, with a brilliant mind on space law and also with respect to the military side of that. He expressed at the end that he was not sure whether he's presenting a sort of pessimistic view of the things. Dale, if I can say, let me continue that. I will really present the really pessimistic view because that's what it is. So when I was invited to make a presentation, I thought, what should I be speaking about? Should be talking about all the things. Recently, in collaboration with one of my research assistant, Nishat Mishra, I wrote an article, which will be published soon in a book. The title of that article is The Beginning of the End of International Space Law. This is a very provocative title, and we intentionally chose that. So I will just give you some example, a kind of summary of our findings and what we have it. So let me say at the outset, say that when we use the term end of law, we use it in the same sense as John Locke used. That is, the end of law is not to abolish or restrain, but to preserve and enlarge freedom. So that's what in essence is. We all know about a month ago, on 5th of January, Saudi Arabia sent its notification to the United Nations to withdraw from the Moon Agreement. This is a unique and unprecedented development, as this is the first time ever a state has withdrawn or showed interest to withdraw from a United Nations treaty. This may initiate a trend for abandoning not only the Moon Agreement, but also other instruments of international space law. In my view, we are witnessing the beginning of the end of international space law. The end of law results in law of jungle. That means a state of affairs in which some gain absolute freedom, while the freedom of others is significantly restrained, if not totally lost. In today's world, the complete end of law may not be conceivable. However, limiting the scope of law, its routine disregard, ineffective implementation, intentional weakening, or clear violation of international law, as we have seen in a recent situation, including space law, with impunity is a cause for alarm, hinting at the beginning of end of international space law. We know that international law, what we know is essentially is sort of codified in 5 United Nations treaties. Outer Space Treaty, which is considered to be the most important space treaty, contains a set of legal principles, principles, morals, and values, which were held at the highest regard by the international community. The treaty reiterates and codified that the exploration and use of outer space, which includes moon and other celestial bodies, must be carried for the benefit and the interest of all countries, irrespective of their degree of economic and scientific development. All states are free to explore and use outer space without discrimination of any kind on a basis of equality and in accordance with international law. These fundamental provisions establish what I call a fair balance of interest of all states and of international community. In brief, one can sum up that the preference of international community was towards valuing, providing for, and protecting inclusive interest and freedom of all states, and with the desire to assert and enhance space domain as a global commons. However, within just a few years after the adoption of the Moon Agreement in 1979, space activities conduct quickly became a hallmark of geopolitical hegemony. Currently, increasing participation, presence, and ever-expanding assertiveness of private entities have further made space domain more exclusive, complex, and difficult. There have a number of attempts, the number of actions, acts of states have gone towards negating the idea of a global commons. Just to give just few examples, that, as I mentioned earlier, since 1917, no treaty has been adopted by COPIUS, and that shows some kind of a standstill. The development of space law is at standstill. Certain countries have started refusing to accept their status as a launching state. This is contrary to the well-established principle that once a launching state is always a launching state. Such a rejection effectively shakes the foundation of international law, which holds the launching state liable for any damage caused by space objects belonging to its public entity or private company. There have been a recent unilateral move by one state to formally and expressly negate the long-standing international consensus that outer space is a global commons. This, in turn, ends the dismantling of the foundation on which international space law has been envisioned and promulgated. Finally, in general, major spacefaring nations have shown no interest in creating a functional international organization to regularly deal with issues related to international space law and regulations. Now, all these things are happening in general international context. So what is the general international context? In recent years, we are seeing aggressive armament, decline in rule-based multilateral trade, continuing environmental degradation and associated climate change events, destruction of ecosystem and loss of diversity and natural resources, overpopulation and increase in refugee and other humanitarian crises, pandemics, and medicine nationalism, global food insecurity, growing energy crisis on a global scale, and continuous destruction of unique cultures of indigenous people. Naturally, all these trends in international relations and the current state of the world have also penetrated in the domain of international space law, space activities. All these observations are not per se a critique of existing international law. It is the failure of the international community to review and update this legal regime that has led to the situation that such an important and forward-looking treaty as Outer Space Treaty is facing challenge to its international principles. Excuse me. Now I will allude to a few examples, notable examples, which negate the expansion of international cooperation in space matters. The first is, of course, unbridled privatization and commercialization of space activities. Just one example. Launch and operation by private companies of mega constellations comprising of thousands or hundreds of thousands of satellites will result in the creation of an extensive space debris and the occupation of fairly large number of frequencies which are limited internationally sourced. Such private space corporations have been able to carry on their operation with no or little regard to appropriate protection of dark and quiet skies and the emerging environmental impact their activities are having on various stakeholders. Additionally, as a result of this participation, private companies, there have been a blurring of the distinction between public, government, and private sector involvement in foreign wars and conflicts, as Professor Stephens has alluded to. But secondly, there's a danger posed by space debris. Militarization of space, and Professor Stephens has alluded and discussed this issue extensively. I don't want to spend too much time on that. Now, the fact is, attitude of some states to assert dominance has resulted in sharp and increased militarization of space activities and expanding both defensive and offensive capabilities. Space domain is becoming a war-fighting domain. And countries have been developing their counter space activities. Some has developed or tested anti-satellite systems. All in all, the willingness of major space powers to take steps to reduce or halt growth of militarization and weaponization of outer space, has been and continues to be a major factor towards the decline in development of and respect for international space law. In September 2011, the US National Research Council warned that space debris has reached a tipping point. This problem is further complicated by the launch and proposed launch of tens of thousands of satellites by private companies, particularly in the form of mega constellation. In order to solve space debris problem, some soft law instruments in the form of space debris mitigation guidelines have been adopted. However, they remain extremely limited as the number of space debris continues to increase exponentially. There's a very limited, if any, hope for the meaningful solution in the near or medium term to the space debris problem. And that problem has caused by a few spacefaring nations, and which is expected to pose constraints on the freedom of use of outer space by all other states. The last point on the issue is it appears that conflicts with respect to exploration and appropriation of natural resources of the moon are already emerging. National isolation of some countries and Artemis Accords may raise, are raising questions on humanity's commitment to collective objectives and motives of sustainable use of outer space. The United Nations Committee on Peaceful Uses of Outer Space has established a working group on legal aspects of space resources activities. However, given the treaty negotiating history of the United Nations and desire of major space powers to have exclusive access to natural resources, the conclusion of any international treaty to regulate space natural resources cannot be expected soon. So what should be done? What is the solution? In my view, it's imperative that global governance regime for outer space must be devised and developed on a multilateral, comprehensive, coordinated, and regular basis. This can only be achieved, as I have previously suggested, through an intergovernmental organization dedicated to space affairs. Such an organization should be charged with the task of expanding and strengthening international rules for responsible behavior in outer space. This organization should actively facilitate the progressive development of international space law in cooperation with other international organizations, the private sector, and should also oversee the effective implementation. Two examples come to my mind is the International Telecommunication Union in Geneva and International Civil Organization here in Montreal. In my view, only such an international organization or international body could effectively and routinely address regulatory requirements of the day as well as of the future. There's a lot of work to be done, and that includes the things which need to be addressed, include planetary protection, planetary defense, cybersecurity, space weather, space transportation systems, standardization of spaceports, space traffic management, space travel and tourism, threat to dark and quiet skies, technical assistance to developing countries, the equitable sharing of the benefits, the need to protect various cultures, and all that number of things. They cannot be addressed on piecemeal basis, one treaty, one resolution basis. There has to be a regular effort made by international community, and that should be done through an international organization. And I mentioned to you, international organizations, which I'm suggesting, should be working in cooperation with other organizations, and particularly the private companies. And then I will say there's an important role for international space law scholarly community. Professor Stevens has alluded to the work he's doing. Splendid work is being done by Adelaide University under his leadership. Similarly, we have been doing work with respect to development of McGill manual. We believe these kind of manuals which are being produced will help in clarifying the law, and that could be used to at least clear the situation, what the law is, and where are the gaps are. I think these are some minor, small, but I think more important steps which are being taken by international institutions or universities like University of Adelaide or McGill University. We have published 52 rules, and we are working on the commentary, commentary on these 50 rules should be available. To conclude, the current state of affairs of the world is grave. Doomsday clock now stands at 90 seconds to midnight. It never happened before. The current United Nations Secretary General reminds us that, I quote, our world is in peril and paralyzed as international law is undermined by geopolitical divisions. However, on the positive side, international community has started reasserting that space is a global commons. On 31st of January, the Space Working Party of the Council of European Union drafted its conclusions on fair and sustainable use of space. The Council recognizes that space, I quote, space is a global commons, a global and shared resource open to all states and all citizens of the world without any discrimination. This very recent and positive step should serve as a common ground to unite the many diverging or differing opinions of states and bring them into a single and pointed plan of action and agenda. And using the phrase beginning of the end, I do not in any way imply that an end is inevitable. Rather, it is an urgent call to the international community to take appropriate actions and resources. Thank you very much.
Thank you very much, Professor Jakhu, for your very interesting presentation, and indeed a much bleaker picture as you promised at the beginning. So I'll open the floor to, I see that Professor Stevens has a comment to make, anyone else if they want. And of course, I invite also the attendees, our audience to write any questions that they have on the chat box. I can see we already have two, and I will invite the panelists to address them in a bit. Professor Stevens, please.
Thank you, Lisa. I'd like to acknowledge Professor Jakhu's standing in international space law. He's probably the major authoritative scholar in the world on this topic, with 40 plus years of experience. So when he has a pessimistic view, that's something we should all take notice of. You didn't, you were true to your claim, Ram. It was a very pessimistic view that you've presented. I wonder, my question is this, it would seem to me, and I welcome your response to this, it would seem to me that an international governance organization would have to have Russia, China, the US and India as part of that organisation. That would be my assumption, and you might disagree. But if that is the case, do you think it likely in the near term that those four countries would be prepared to form such an organisation, or be at the vanguard of forming such an organisation?
Thank you very much for your compliments, Dale, and of course at least I'm not used to calling you Professor Stevens, but I hope you don't mind that. Thank you very much. Your assumption is absolutely correct, but at the same time there's a term in French that says nécessité fait loi, that if it has to be done, it has to be done. The tragedy of our civilization has been that when millions die, then we wake up and do certain things. I think I think we are civilized people, or I assume we are civilized people, the civilization. We can avoid that tragedy. Like we've said it, at the end of the Second World War, we say never again. So we're doing that kind of thing. But particularly with respect to China, Russia, India, and other countries, I think one has to be very cognizant of the fact, actually, these are the countries who have been pushing for that. They are the one who is coming up with these kind of rules-based order. Sad thing is the Western countries are reluctant to do that. I can elaborate that one, but they are on the other. Now, of course, they're not coming, for the good of humanity. I'm sorry to say, they're coming because it is in their interest, and that is true. It is the interest of everybody. Particularly in space, I will say it is in the interest of the major space powers to have clear rules of their own. Small country which doesn't use satellite, care less. That country should care, but it is a major country which needs those kind of things. So it is a self-interest which should be done, should be taken into consideration. That's the one which should be the basis for this kind of. Now, these are, I admit, these are academic points. And I'm not the first one, by the way. It was 70s, 80s, 90s. This was made for proposals were made towards that. But I think the time has come. I just put a list of the things which needs to be done. You cannot have a treaty on each issue any time and every time. There has to be continuous revision of the thing, updating the implementation. And the brilliant example, which I'm very familiar with, ITU. ITU just finished a conference, last few months ago. I mean, they meet every 4 years. The private sector is very active in that. It is the most active, successful organization. So I think humanity needs that kind of thing. And the time has come to start looking at it. The debate has to take place.
Thank you.
Great. I will go now to the questions of the audience.
Dr. Mardikian, before we go to
yes.
the audience, if we can ask also a question here to Professor Jakhu, and then of course we'll go to the audience and the rest maybe of the colleagues if they want maybe to ask another question. Professor Jakhu, the question is about the issue that you spoke about the International Telecommunications Organization as an aspect, as a prototype of the space-related organization. Space law has public law facets, as Professor Stevens spoke before, the laws of war, and private law facets, as you spoke about the corporations. But do you think an international organization can embed both aspects of law? All the more so when in domestic law we have a clear distinction between private law and public law.
That's a very good question. When I mentioned, or when I proposed this organization, doesn't mean it has to do everything. There are the things which needs to be done by conference or disarmament, for example, but needs to be looked at some other organization, health matters with respect to space, perhaps World Health Organization should be there. What you need is a lead institution which can do that. I will personally would like to see the military side being taken care of by conference on disarmament or the Security Council. So early on the civilian side, but ever, there should be organization like that. Take the example of planetary protection. Planetary protection in MOE or of space traffic management. Those needs to be done. Space debris is an issue to be taken care of, or the natural resources need to be taken care of. Those are there are major issues in the civilian side, the commercial side, which needs to be worked on that. Now, I may take a point. Now, often we have been hearing and that we don't need treaty. The world is not ready for the treaties. I think it's not logical. Can you imagine $1 trillion worth of industry can work on the basis of resolutions or non-binding instruments? Can a country allow a rocket or a spacecraft bringing the tourists to its land without a treaty? We cannot tolerate, balloons. How will you tolerate somebody's spacecraft coming? So there has to be binding treaties or, regional basis or bilateral basis, which the rights and obligations of the parties are set together. And there's no one universal rule. It has to be custom made, but one organization has to be in charge, raising the issues, trying to address that, doing some work, getting the experts involved and technical people, policy people, economists, scientists, all together, private sector involved to do something. The time has come. Otherwise, we will be in a very bad shape. That's.
Thank you, Professor Jakhu. If there are no further questions from our colleagues at the panel, I will read you the 3 questions that we have from the audience. From Eugene Holstein, he asks Professor Stevens if you could elaborate what medical satellites are and how they work. And I know you commented a bit more on the satellites, but if you have any further observations. And then 2 related questions from Odilia Coy. How could Article 2 of OST deal with the Artemis Accords, which disconnect the concept of ownership and that of resource extraction? And the 3rd from Doug Ligor, do the Artemis Accords, specifically the safety zone and extraction of resources clauses, violate the OST's Article 2 non-appropriation clause? If so, why are non-spacefaring states and other states being disadvantaged by this not asserting this fact? Professor Stevens, would you like to address the questions?
Sure. Thank you. So in respect of the medical satellite question, at the moment, there is no exclusive designated medical satellite in orbit. It doesn't exist. The Red Cross, the International Committee of the Red Cross in the 1990s did foresee the possibility of this occurring and did provide a supplement to their protocol that spoke about how such a satellite would be able to be designated, would be able to send signals to be so recognised. So the concept itself has been foreseen by the International Committee of the Red Cross, but it hasn't yet, we don't yet have such a thing. But I think we might. And I think the context of how we might is, as I mentioned in my short remarks, is that I understand, and I'm just a lawyer. I don't know how medical science is developing, but I understand that it is possible to have telesurgery and from one country to another, into a battlefield, to a battle space, where surgeons in one country can somehow, through telesurgery, do effective treatment in another country. That's what I'm told. And if that is the case, then I can foresee the possibility of designated satellites in an armed conflict having that exclusive medical role. And if they have that exclusive medical role, then they would get protection, like all medical units do in an armed conflict. So I think this is a thing for the future, but I think it's in the near future. I think it's not just science fiction. I think this is something that will likely happen sooner rather than later. As to the other two questions, I'll defer to Ram on those two, but my comment would be on Article 2, is that Article 2 clearly says there is no appropriation, clearly says that. But there is some debate about whether or not mining is appropriation or not. And if you take the view that it is not, then things like the Artemis Accords are not in conflict with Article 2. They seek to regulate how, or provide the framework for regulating how that mining will take place. But I fully acknowledge that there is controversy and debate over this whole issue. So I will just handball that question onto Professor Jakhu.
Thank you very much. First thing, I agree with you. I think there's a controversy, and I think there's some merit in that controversy. But I think it is also based on some ignorance on the treaty and the negotiating history of the treaty as such. I fully agree with you that Article 2 is very clear. If you look at the negotiating history of the treaty, it was considered that they should not be appropriation by anybody, but that's why the word by any means of that was there, private or that sort of thing. Now, normally it is said that mining or natural resources are not included in Article 2, and that is why appropriation is allowed of those resources. To me, that's a totally illogical argument. Let's take the example. Article 4 of the Outer Space Treaty says that weapons of mass destruction shall not be installed on celestial bodies. Now, the word moon is not there. Does this mean you can install weapons of mass destruction on the moon? Now, and then Article 4, it says, moon and other celestial bodies shall be used exclusively for peaceful purposes. It doesn't say exploration. So the exploration can be for military purposes. So these are self-centered, self-serving interpretations. And secondly, we should not forget, Outer Space Treaty is not, it is a treaty on principles. The principles are broader. There is always room for improvement, it should be. And that is why you got Moon Agreement to improve upon the Outer Space Treaty. And Moon Agreement allows the appropriation for specific purposes. It also gives you the roadmap to go further than that. So that is my view on that. Artemis Accords, I have my own opinion on that. I think it is based on that perception or assumption, which I think is wrong perception. With respect to safety zones, In my view, if you look at the idea behind safety zone, the way Artemis Accord have been negotiated, to me, they are in fact, they're security zones. They are not safety zones. But saying these are security zones, there's a clear violation of Article 4 of the Outer Space Treaty. So that is what is avoided in that. Now, unilateral declaration of any zone is contrary to Outer Space Treaty. Yes, safety zone could be or perhaps should be agreed upon by international community. So that is very important. Now, question is, you are unilaterally declaring and marking the demarcations of these hundreds of thousands of kilometers, or whatever it is. I think it's a very unilateral action, which in my view is not appropriate. It's not in accordance with at least the spirit of the Outer Space Treaty. In my presentation, I mentioned Outer Space Treaty does not include provisions, legal provisions. It also provides values. The morality is very important to that. And I think that's the way I see. And I may also mention, I don't really see any contradiction between Moon Agreement and Artemis Accords. We have a brilliant people and a wise government in Australia. And that's what they said. And that is, I think, the people do not fully understand that there's no inconsistency between Moon Agreement and Artemis Accords. I will prefer countries stick to Moon Agreement. I will, if I have the authority, I will make official invitation to countries like China, Russia, India, Germany, or other countries to join Moon Agreement. This is the time. There's a time, there's a something has said they want to withdraw, but the other countries should take hey, we need rules-based order in space, because it is in their interest. It's not in the interest of the international community, but their interest, the rules of based order is maintained, particularly with respect to mining.
Thank you both to our panelists for your answers. We have one more question from the audience, from Vagar Mamadov. Could you please talk about the application of the precautionary principle in outer space activities? Professor Stevens?
So the context in which I used precautionary principle was in the context of armed conflict. So in the context of armed conflict, you have a set of requirements that you take precautions, that you need to take precautions when undertaking a lawful attack. And those precautions include questions of identifying that this is a military target, choosing your methods and means of attack, such as to reduce civilian casualties and damage to civilian objects. You use a weapons system that does that. And what I am suggesting, as countries talk about the potential for armed conflict in space and how to limit that, I'm suggesting that when you are looking at satellites, that the question of using kinetic means, using rockets to blow up, physically blow up satellites, causing debris to go everywhere, I think that the precautionary principle in the law of armed conflict provides a very big barrier to you wanting to do that. I think that it's not impossible. It all turns on feasibility. But if you've got another means, such as a laser or a cyber, or just knocking the satellite out of its orbit, just bumping it or spinning it, or I'm told even spray painting it. And I've got some people down at my local railway station that are pretty good at that. So we could send them up into space. They could spray paint the optics of other satellites. But there are ways of making a satellite, neutralizing a satellite that don't include blowing it up and causing debris to hit every other satellite up there. And I think that we will see, in the unfortunate event that should armed conflict occur in space itself, that this principle will become more prominent in space than perhaps it is here on Earth. So that was the context in which I was explaining that concept.
Thank you, Professor Stevens. Professor Jakhu, maybe you have a comment on this question?
To be honest, I am not very much familiar. This is not my field of expertise. As you know, before the start of the webinar, I requested Dale to come to my aid in case there's an issue of that, and he did a brilliant job. The only thing I know on the environmental law side, and that precautionary principles are considered to be part of customary international law, and that need to be respected. All these matters, and as a matter of fact, I would say the precautionary principles are broader now, and the way I see, broader than environmental law. So what they say, what could happen, would happen. So one has to be careful. Simple.
Great, thank you. I don't see any other comments or questions at the Q&A. So if also our colleagues here at the panel don't have any other questions, we might bring this event to an end. I would like to thank you warmly, Professor Stevens and Professor Jakhu, for their very interesting interventions. And I'm mindful that it is after 12 in Australia. So it's time for the event to come to a close.
I'm actually in the future. I'm in your tomorrow. I can tell you what the future holds.
Exactly. We warmly help you also. Thank you very much also from the BUL International Law Directorship here. And we look forward also to say to the audience to the next BUL International Law Group event, which is going to be held in March. And once again, the video of this event is going to be uploaded on the Brunel Law School YouTube channel. To thank you, of course, Dr. Mardikian, for the excellent sharing of the panel, all the colleagues who participate, and you, the audience, of course, and to renew our meeting for the next event in March. Thank you very much.
Thank you very much for inviting us. Thank you. It was a great pleasure to be participating in an exciting discussion. Again, thank you very much, Dale. It's good.
Thank you too, Ram, and thank you, Solon.
All right.
Thank you. Good night.
Good morning. Good morning.